overlooked estate planning document? Number one most overlooked.
Financial power of attorney. It's the most important. It's overlooked because it's often not done right. A lot of times people will do these online, and what they don't realize is there's so many things that I see every day. It's not one document fits all. Banks are changing their rules every single day.
Welcome to the Advisors Fuel podcast, where high-performing financial planners and wealth advisors discover proven processes and actionable strategies to elevate their client experience, grow their businesses faster, and achieve unprecedented success. Here's your host, Adam Koós, founder at Adrenaline Advisor Consulting at adrenalineadvisor.com.
Hey everyone, welcome back to the Advisors Fuel podcast. Today's conversation is all about one of the most overlooked drivers of trust, retention, and long-term value inside an advisory practice, and that's estate planning. I'm joined today by Dan Baron to break it down, and we're going to dig into the blind spots that advisors see every day, why so many clients think they're covered when they're not, where probate risk actually shows up, and how better estate planning conversations can dramatically change the depth of a client relationship. So if you work with business owners, families, or multi-generational wealth, it doesn't matter. If you want to better protect your clients and your practice, this episode will give you the clear framework for asking better questions and avoiding costly mistakes. So enjoy the episode. All right, everybody, welcome back to the Advisors Fuel podcast, the show for financial advisors who want to grow and scale smarter, serve better, and build businesses that last. Today, I am joined by Dan Baron, the founding member of Baron Law LLC, where he focuses his practice on estate planning, business succession, and asset protection. Dan is a nationally recognized attorney, voted an Ohio Super Lawyer Rising Star 5 years running, named Best Lawyer One to Watch in 2024, and he's ranked among the top 50 estate planning attorneys in America. He's also a published author, founder of Dollars and Cents magazine. He's an educator who teaches estate planning and asset protection at several colleges throughout Ohio. He's also known for taking complex legal topics, easy for me to say, and breaking them down into simple, actionable guidance for families, business owners, and financial advisors. So today we're going to dig into the estate planning moves that deepen client relationships and drive referrals, specifically hidden planning gaps, how trusts actually work, how advisors can use estate planning conversations to differentiate themselves, and what it looks like to build a powerful attorney-advisor referral relationship. And I hesitate to use that word referral. I don't like it, to be honest, but call it alliance, right? So thank you so much for joining me. This is the second time I've had you on a podcast.
Yeah, thanks for having me.
For sure. You and I, we literally just finished co-hosting a webinar together. We had 24 RSVP'd. I think we had 13 or 14 on the call. And one thing that stood out to me was how many advisors don't fully realize the estate planning blind spots, as you called them, sitting inside their own client relationships. So I'm kind of excited to unpack that today. Did you feel like you saw anything or heard anything that
Yeah, I mean, just even from the question, at the end, listen, when it comes to growing your assets, that's not my wheelhouse. Like advisors are way smarter than I am at doing that task. But when it comes to estate planning, it's kind of like stay in your lane, because there's a lot of disconnect, a lot of misconceptions of what maybe an advisor believes or has heard versus what reality is.
So as a top, I have to lead in with this, as a top 50 attorney in the country, you have a pretty unique story of how you got there.
Well, first off, my mother was the one who nominated me for that top.
Did she?
50.
Okay. Well, then that's all that matters then. Yeah. But no, in all seriousness, what, tell us about your journey, how you ended up here. Cause it was not, unorthodox.
No, 100%. So I wasn't always a lawyer. I used to own a landscape construction company. I was mowing lawns just like, a lot of young kids at 11, 12 years old. Well, that actually turned into a pretty big business. So I moved out of my parents' house when I was 17, a junior in high school, because I had all this equipment. So living on my own, junior and senior year in high school, went to undergrad, and that business grew into a 20 employee enterprise, and ended up doing a lot of outdoor living spaces. So I have that context of, working with a lot of business owners. But then throughout that, and I was like, okay, what's next? I got tired of managing that business. And so I had some family things happen with my grandma, and went to law school, in the mix of that at the same time, had a death in the family, and just kind of saw how there's a need for estate planning lawyers, probate attorneys and elder law attorneys. And so that's the reason I took the path. So in the lab, been doing this for 10 years and I love it. I get paid to help people. There's nothing greater than that.
Yeah, I'm with you. I would say that I feel the same way about our career. We financial advisors, I feel like there is no better business in the world where you can literally help people, and make a pretty good income doing it. So it's pretty amazing. What would you say are some of the, I don't know, we'll say most common, call it hidden estate planning gaps do you see when clients walk into your office?
Um, well, first off, a lot of people don't realize that a will does not avoid probate. They think, oh, the will is going to be the end all be all, and it's absolutely not. You need to consider things like beneficiary designations, TOD designations, a trust. So, would love to talk about a trust a little bit more, but a lot of advisors think that just naming a beneficiary is enough, and it's not. It flat out isn't. Some other things are overlooking incapacity planning. So if you don't have your advance directives, or if your financial planner, your financial power of attorney put in place, then you're leaving it up to a court and a guardianship to decide who that person is. And that's a big thing because 37% of the calls that we get are from a child and who says, "Hey, mom or dad's incapacitated, and we need to establish financial power of attorney." Hey, guess what? It's too late because if the child is calling me and they're the ones who are trying to establish this POA, the child cannot do that. It has to be mom or dad or whoever it is. They have to establish it for themselves. And that is so common. And I get calls from financial planners of, hey, we need to get POA for this person. It's too late. They have to do it themselves. They have to be of sound mind to sign that document and to name someone else because otherwise, I'll give you an example. It's probably around 6, 7 months ago, had a client and he came in naming his daughter as power of attorney. Well, he used to have his daughters as co-agents. He took one of the daughters off for simple reason that she lives in Germany. So, out of the country. So he ends up, of course, passing away. And within the time frame of when he took the daughter off, and he was of sound mind, now the other daughter realized months later that she's no longer POA and she's no longer executor. And so, of course, she's questioning whether or not, dad was of sound mind to do this in the first place. And it makes it a gray area. Me as the lawyer, I know that he was fine, but I don't want to be put in that situation. And so that's why you can't wait until you're in your 80s to get this stuff done. You have to get it done ahead of time.
Yeah. I mean, that's just one example. I know we talked about a lot of blind spots on the webinar, and I don't want to duplicate too many of those efforts, but what would you say when it comes to financial advisors? Let's talk about why estate planning is such a powerful relationship tool, often overlooked. I know the statistic is 54% of people don't have an estate plan. That's clients, right?
Mhm.
So let's talk about why estate planning is such an underutilized, powerful relationship tool for advisors, whether it's for retention, multi-generational planning I talked about on the webinar, risk mitigation. Which of these do you feel like financial advisors underestimate the most?
I would say they underestimate clients with businesses and clients who own real estate. I think that they're overlooking those the most in terms of what to do with those clients, and they're not addressing those in an appropriate way to make it efficient and to avoid probate court. When you talked about multi-general wealth, that's also a factor, but a lot of our clients I don't have statistics, but there is a great transfer of wealth that's happening right now, and a lot of advisors aren't really considering that, and so they're just naming beneficiaries on accounts, and long term that's going to have a huge effect because instead of looking forward of the grandchildren and so forth, they're just naming their kids as beneficiaries on 401ks, IRAs, and so forth. And without considering the long-term effects of that's gonna have a great impact. 30% of our clients have businesses, and they are just often overlooked. And if you don't address the business itself, coupled with a trust, then and I don't care if it's a sole member or it makes it even more complicated if you have, clients with, multi-member businesses, then it is a mess. And you can either address the business itself as its own estate plan, or you can bring it into a trust. And if you don't do that, then it's just a huge mess.
Yeah, we're going to talk
Clients,
about trusts for sure. Go ahead. Sorry.
clients with, I think advisors overlook real estate.
Hmm.
They just focus on the assets that they have right in front of them, and whether it's 401k or what have you, and they're not considering those assets that the clients have outside of under that's not under their management. And there's a lot of different ways to address real estate, but a will is not the way to do it. Because just having a will, you're going to spend a year or more in probate court.
Here are the statistics. I pulled them up here from our website. So there's 52% of people don't have an estate plan at all. 72% don't possess a comprehensive estate plan. So they just have part of it, but not all of the things they need. 58% of individuals haven't organized their online passwords. 47% of people don't have an advanced healthcare directive. 30% of people with an estate plan have no idea where their documents are. And then 54% of people who have an estate plan haven't informed their executor or trustee about the location of these documents. So if something were to happen to them, I don't know how good it is anyway if they can't find it.
I I think I mentioned this in our last segment. I really would love to start a reality TV show, and I'm telling you, it's off the top of my head. I could think of 10 cases that we have right now where I'll give you one. Dad created a will in the 1990s, right? And he disinherited some of his kids. Another kid has special needs. That's a big deal. Okay. So, all right, you made your wishes known. But what happens over the next 30 or 40 years? Things change. You've rekindled your relationships with people, right? And so the same thing happened. And the whole family is like, we know he has a will because he passed away, of course. And the whole family's like, we know he has a will. He doesn't want to disinherit this person anymore. But he deposited that will with probate 40 years ago,
Yeah.
and the court has to follow it. Another case, mom created a trust, disinherited her son, and she did this in the 90s, and things changed. The relationship was reunited. Son was very much involved with mom in her last days, and mom was involved with grandson. Okay, happy family. Well, her trust that she created X number of years ago names a nephew who she's never met. Nephew is inheriting 1.5 million because she never updated her trust.
Wow.
And that's another case we have. Like, you can't make this stuff up, and everything that's in her house is a connection between mom and son and mom and grandson. There is zero connection. I had to, just a couple of weeks ago, have the nephew come and like, "Hey, is there anything in the house that you want? Because otherwise I'm gonna donate it to the kids," like pictures and stuff like that,
Yeah.
right? You can't make this stuff up.
Wow. Yeah. I'm sure
Yeah.
you have plenty of stories. Back to financial advisors, though, before we talk about trusts, because I want to talk a lot about trusts. How often do you think financial advisors are 100% certain their clients are avoiding probate?
I don't have a statistic. I wonder if you could pull that up, but I would say the majority of the time that advisors, because I see this all the time, they're like, "Oh, my advisor says I don't need a trust," or "My advisor says all I need to do is just do this transfer on that. All I need to do is this." I think advisors, again, they're a little myopic in just looking at the assets under their management, but they don't consider, what about the car? What about tangible personal property? Are there specific bequests? Is there a vacation home? What about their real estate? So I would say the majority of advisors think that their clients are avoiding. And you would also be amazed. This one really astonishes me of how many advisors think that I have a will. So my clients have a will. I did it online. I went to LegalZoom. They've got a will, so they're avoiding probate. A will does not avoid probate. Does not avoid probate. So I would say the majority of them though do, or they don't care. And that's, at least in my world, we all want to grow our money, but the important thing to me is, hey, I want to make sure that we're avoiding probate court.
Yeah. Okay, interesting. Because I know that even avoiding probate isn't even the most important thing in the world when it comes to estate planning anyhow. I mean, it's obviously a hot button, right? But, what are some questions that you feel like advisors should be asking or should be asking to uncover these estate planning issues before they become real problems, understanding that they're not attorneys, but how do they find those, stones and turn them over?
You should always revisit the plan. So, questions you should ask are, any additions to the family, any new uh, purchases, like real estate specifically. Has anyone passed away? Are there any divorces? Um, those are big questions. What about capacity issues? So, oftentimes I'll meet with a client and I question, hey, is Joe Smith even does he really comprehend what's going on in this conversation? And so those are questions, because oftentimes, especially spouses will hide it, and they're like, oh, he's fine. I just had this yesterday. And it's like, I don't know if this guy is, really able to sign here. So capacity issues too. I mean, those are tough. You can just generally ask them about their health, and it'll naturally come up. Like, oh, yeah, Tom's got some memory issues. We talked about this, and so those are definitely things. So any major life events are questions that you should ask. When's the last time that you revisited your plan? Which, by the way, I would say every 3 to 5 years. That does not mean that you need to change your plan. On average, we're probably making a change in a client's plan maybe every 10 years. And often that change is not a change in the law. It's mostly not a change because of a document or something is outdated. It's mainly because there's a change in the family. And that's why there's a change that needs to happen.
Yeah, kids got older, they're adults now, maybe we're not
Yeah.
married anymore, remarried. All kinds of
Yep.
different things, yeah. You had, a great slide in your webinar where you said, or you asked, are your clients aware of what actually happens after death? And how would you explain that reality in a way that clients are gonna understand it? So if you're the advisor.
Well, first off, clients, everyone, just they kind of have this instinctive nudge to call their attorney or call the advisor and think that the tax man or someone's going to be knocking on their door the very next day after death. That is not true. The reality of it is, no one's going to come and seize your home, or you don't owe anything right away. Life just continues to go on. So what really happens after death is to just take a breath, first of all, and just grieve. And that's what I always, tell a client. Um, in terms of what actually happens, there's a lot of assumptions. Oh, you're married, so you're gonna get these assets. Not necessarily. You really have to look at the family dynamic, and you really have to look at what is set up to truly understand what actually happens. Um, I think I use this example of where husband wife, and he assumed that his spouse would get the everything because he was married, but he has 2 kids from a prior marriage, and, he was wrong, and he just assumed that, and what actually happened is his kids from a prior marriage, who he hasn't talked to in 20 years, they got 2/3 of $1.5 million. I mean, that is a retirement life changer. um, so, again, I joke about the reality TV show. I can't tell you how many times I've seen advisors or just the average client make the mistake of assuming that because they're married or because they have kids or because they have a will, that they have a certain predetermined outcome that they think is going to happen, but that doesn't, because they don't understand the law. And that's really what it is. If you don't understand the law, then you don't understand the outcome.
No, that makes sense. Um, I wanna talk about trusts because so much of this can be fixed, with a trust as opposed to just a will or, beneficiary designations or even TODs and PODs, right? But, often I think the problem is financial advisors, we often hear about trusts, but we aren't so clear on when they're appropriate. So what would you say are maybe the clearest signals that a client of ours, genuinely needs a trust?
Okay. So let's start with um, the no brainers.
Okay.
Okay. All right. So if you have minor children, you need a trust. Hands down. Minor or irresponsible children, you need a trust. a 9-year-old legally cannot inherit. So you cannot name a 9-year-old as a beneficiary of a life insurance policy. If you did, and I had a client do this by accident, under advisement of their advisor,
Mhm.
under the direction of their advisor, they told them to do this. Well, of course, they didn't think that the guy was going to pass away in his 40s, and he did. And all of that money now went to probate court. It did not avoid probate. Okay. And all of that money is under direction of a guardian who is not the mother of the children. And so now she has to go and ask for every dime. So if you have minor children, setting up a trust is very important because the money goes to the trust directly, and then you can choose whoever you want to manage those funds. So I use the 9-year-old as an example. Okay, well, if you have young children, do you want a 19-year-old inheriting $1 million? Probably not. So that's where a trust comes in. So those are the no-brainers. So then we get into, okay, probate. A trust is one way to avoid probate. It is not the only way. The next no-brainer, though, is if you own real estate and if you have more than one beneficiary that you intend to inherit that real estate, then I recommend a trust. And the reason why is one of the ways that you can avoid probate with real estate is through something called a transfer on death designation. So these are generally drafted by attorneys, but not necessarily. Some counties will offer the forms, and you name whoever your beneficiary is, and they inherit that real estate without probate. So upon death, they give a death certificate. Now that real estate goes to their name. But if you have multiple beneficiaries, it's problematic because not only do all of your beneficiaries, let's say there's three of them, three kids, have to agree on a sale price, but so do their spouses because the spouses have dower rights. So with real estate, so now if you have three kids and they all married, now you have six people who have to agree on a sale price, and that it is a mess, and all of them are signing off on it. So definitely a trust if you have real estate with multiple beneficiaries. Some other things that I don't want to. I'm not going necessarily in order, but again, we mentioned business owners definitely have a trust or have a estate plan for the business itself. If you're concerned about your kids getting divorced, or you can name someone as a beneficiary on a 401k, yes. If they inherit that, however, they commingle it with their joint bank account, it's subject to a divorce. So having a trust can help there.
If you're a business owner, don't have your company own the real estate.
Yes. If you're a business owner, I would recommend having a separate LLC
Mhm.
for any business owned assets. Typically, it's very common. Let's say it's a manufacturing company. You'll set up a separate LLC. And so LLC ABC owns the real estate.
Mhm.
And then that ABC company rents to the manufacturing company. So this way, if the manufacturing company gets sued, then the real estate's not included in that lawsuit because
Yep.
they're separate.
And when they wanna sell, they can be more tax efficient with it upon sale. Sell the business
Correct.
separate from the real estate too. What about co-executors? I've run into this before, and I don't know if other advisors that are watching or listening to this have or probably will someday. When you've got, a trust and then you've got three co-trustees, I found that to be a really big pain. Is it unavoidable? I mean, is there a recommendation? Like, sometimes I think people feel like they're being slighted because they're not the smartest or the oldest, right?
This is a really common question that I get, and a difficult one that I have with clients. I don't recommend co-trustees or
Mhm.
or co-executors, period. And in fact, if it's a will, that's what our executor, a court won't typically allow a co-trustee. They'll just say, "Hey, you have to pick one." And the reason why is for the obvious. There could be a deadlock and where someone doesn't agree, and that's why you put someone in charge. You're right. You want to be as a fair, and sometimes that's not the best thing to do.
Yep.
Certainly, you can't name multiple people on something as simple as a healthcare directive, right? Healthcare POA, because the hospital's not going to wait for another person to make a decision if they have someone who can make a decision right now. Time is of the essence. Short version, I don't recommend it. Oftentimes, a hospital or bank won't allow it, so don't do it. You can still name, let's see, you have 3 kids, you could still name all 3 kids, just not as co-agents. You would name them in
Successors.
hierarchy, yeah,
Yep.
so first, second, and third. Yeah,
Okay.
and then communicate. So, you don't need a lawyer for this, you don't need your advisor for
Yeah.
this, like, you know, communicate this to the family. "Hey, this is who I've chosen." But if you're advising your client, you know, don't have co-agents.
If you can avoid it. Okay. Um, I was curious because that was my personal opinion, but I don't know if it was the right opinion. So on the flip side, trust planning wise, when is a trust not necessary, even if someone might think it is?
Yeah, well, I can tell you what you shouldn't say, and then I'll say where it's not necessary. I hear all the time, "Well, my advisor says I don't need a trust because I don't have enough money." Not necessarily true. I did a trust for a client who has $50,000 to their name. And why? Because he has a special needs son. And I have to do a trust because if he passes away, his needs son, who's a paraplegic, who's on SSI and Medicaid, even though he has only $50,000, needs a trust because if that money goes to that son, then he's kicked off of his benefits, right? But some other circumstances where a trust may not be necessary is if you have younger clients, not married, no kids, so single, no kids, and maybe they're in their 20s, 30s, and they're just leaving everything to mom or dad, or they're leaving it to brother or sister, no problem. But if they're leaving it to niece or nephew, ruh-roh, you have a problem because niece or nephew are probably minors. But your college kids, your young professionals who, if they're just leaving things to mom or dad or brother and sister, then I don't think a trust is necessary. I really don't. If there are no minor children, that's a consideration, but I caution there, if you're in your 50s or 60s and you're naming your brother or sister, well, if your brother or sister have medical problems, or if you're naming your parents and they're in a nursing home, then you might need a trust because you don't want that money going to the nursing home. Married couples who have everything joint and they're only leaving things to one person, a trust may not be necessary.
One child?
One child, yeah, one child, one lawyer. They're leaving everything to their lawyer.
So even a minor child?
No, not a minor.
Okay.
Yeah, no minor. So husband, wife, 50s, 60s, 70s, and they have an adult,
Okay.
no child, then no problem. But lastly, if the costs outweigh the benefit. I mean, I have clients that got kids, and there are ways through a will where, yes, if mom or dad pass away, they're going to probate or their estate's going to probate. So a court is going to oversee the assets and the guardianship of young children. And in those cases, hey, at least they did something. Yes, there's court involved, but that's better than nothing. And even though the court's involved, at least their wishes are met. And so in those cases, depending on the cost, then yeah, sure. Then don't do a trust, but at least you have something in place, which would be through a will.
What would you say are the most, just in plain English, the most common trusts that people are putting together these days? I mean, there's obviously, your revocable, your irrevocable, your slats, grats, there's all these acronyms, right, in your industry. But and half of them, I think most financial advisors we don't understand them, which is why you have a job, partially, right? But which ones do you see being the most frequent, at least most frequently needed?
So first off, there's a lot of buzzwords. Uh, Anytime I watch TikTok, I cringe because I see people on there who do what I do, and they're like, "Oh, you need this legacy trust. You need this
Oh,
living
geez.
trust." And I'm like, "You're just confusing people."
Yep.
Just so a lot of different buzzwords. The most common way for the average person is setting up what's called a revocable trust.
Mhm.
This revocable trust is also referred to, so this is where it gets confusing, as a living trust, as a family trust. They're all the same thing. It's all
Mhm.
the same thing. It's a document that tells the world who gets what, that you can change. Okay, revocable is a fancy word for it's amendable. All right. So you can make changes. It's a living trust because you're alive while the trust is there. You can still make changes. Referred to as a family trust because you're keeping the assets bloodline. Whereas by just naming a beneficiary designation, you can't do that. The trust creates that bloodline relationship. So commonly, you're setting up one of these revocable trusts with the goal of avoiding probate court, okay, and providing protection for your beneficiaries, typically your kids. So the trust will make sure that all of the beneficiaries, their health, education, maintenance, and support is taken care of, never going to leave them on the streets. But if they're on drugs, in jail, going through a divorce, getting sued, having creditor issues, that is what the trust is designed for, is to protect your legacy. It's typically how it's set up.
Okay. And then irrevocable. What percentage of the trusts that you set up are revocable versus irrevocable?
80 to 85% are probably revocable.
Mhm.
Irrevocable trusts are are only necessary in a couple of circumstances. One would be your high net worth client. Two, which I just led with this, would be a long term care scenario. So long term care, we use irrevocable trusts to hide money from the government. We're essentially making the person broke on paper. So since long term care affects 60% or more of us in terms of assisted living or nursing home, we would use an irrevocable trust in a scenario where, let's say, client has $500,000 in investable assets and a $300,000 house, and they're married. Well, in Ohio, if they're 65 or older, they would be on Medicare for the first 100 days. After 100 days, they're paying out of pocket. So if they don't have long-term care insurance, which a lot of people don't, they're dipping into that $500,000 and they're paying $10,000 a month for a nursing home. Once they spend that down to $157,000 in Ohio, now they're eligible for Medicaid. So Medicaid kicks in. How do they get paid? They put a lien on the house. And so where the irrevocable trust comes in is in that scenario, I would put their home into an irrevocable trust so that when they go to put the lien on it, they can't because the client doesn't own the house. So long-term care is a big reason for an irrevocable trust, but if that same client had 1.5 million, I would not do it because it's highly unlikely that they're going to spend through 1.5 million in a nursing home where Medicaid's going to come after the home. High net worth or privacy. We have some athletes that we work with, and we create just an irrevocable trust or revocable, either way, actually, so that their name is not on it. So if they purchase properties, it goes in there. And they, couple of things. So with our doctors and athletes, they're just living off the income. So if they got sued, then the irrevocable trust provides protection. And then also irrevocable trusts, if you're above the estate tax exemption, 15 million per person, then the slats and grats you mentioned, they can reduce taxes for the family.
So I was just going to ask about favorite charitable trust. Do you have one that you feel like, checks most of the boxes, the most, call it, I don't want to say most popular, but whatever your favorite is?
What's funny is donor advised funds, I think those are a really good way to leave money to charities, and it's not even a trust. Not even a trust. So you don't even necessarily need a lawyer. And I think donor advised funds are a good way to leave the charities. Charitable remainder trusts are another way, and you can get a tax break. We don't do a lot of them. They used to be a lot more common. But
What's the
now
downside? So what's the downside or the catch with the charitable remainder trust? Because my understanding was always that, whatever you put into the trust is an immediate tax write-off. There is no tax owed on any gains or income within the trust while it's basically in force. The owner, or beneficiary is technically obviously not the owner, but the grantor of the trust can get tax-free income, right, while the trust exists, and then when they're gone, hence the remainder of those assets goes to the charity that they chose up front. I feel like I'm missing something there. I feel like there's a catch that maybe laws have changed, but does it not work like that anymore?
No, it does, and it's been a minute since I've even done. I think the last one I did was last year for a charitable remainder trust. But it's not. If I recall, you're not getting a deduction off the full amount.
Okay,
Yeah, so that's something
interesting.
that. Yeah,
Huh.
there's charitable remainders. There's other ways to set it up where sometimes you put a lump sum And other times it's more like payments over time or an annuity. There's a lot of different ways to set it up and pros and cons. I think that the big thing though, just overall, whether it's an irrevocable trust or even if you're setting up a trust and giving to charities within a revocable trust, the benefit of any trust or a donor advised fund when you're giving to charities is that you're putting someone in charge that you need. We have clients who have foundations that they've started.
Oh yeah.
Uh, and well, what happens to the foundation when you die? The foundation dies, and
Right.
there's no one there to manage it. So then it ends up going to probate. So that's why having any kind of trust, and yeah, there are certain tax benefits with charitable remainder trusts that you can get, but it's really just putting someone in charge. So I think I mentioned in the last segment that I asked an advisor. He had a charity that someone named in an IRA, which you can do, and there's some tax benefits to that.
Hmm.
But it's been sitting there for 8 years because no one's doing anything about it. So, and I don't know if
Interesting.
I don't know if that's the advisor or Fidelity's fault or whatever, but
Yeah.
just sitting there.
Speaking of advisors again, from your perspective, what do you think makes a financial advisor, great to collaborate with? And what makes a bad one? Because I think one of the things that financial advisors struggle with is, they've been taught when they first start in the business that, you need to meet some attorneys, meet some CPAs, maybe some business bankers, what have you, insurance agents maybe, and, build relationships. And then the goal is, to send some referrals their way and, hope that turns into a two-way street. I personally always like to tell people not only the advisors that I coach, but attorneys that roughly 83% is the last number I saw. 83% of clients come to attorneys from financial advisor referrals. So it's really difficult for attorneys to refer back when much of their business is coming from a hand that they don't want to bite, right? You don't want to eat the hand that feeds you, right? But
Yeah.
still, that leaves another 17%, which isn't terrible. So what makes an advisor a great person to collaborate with versus somebody who's not?
A great advisor is someone who takes a comprehensive approach and isn't just picking stocks. Um, you know, when I deal with a client, we always reach out to the advisor for help on titling accounts to a trust or making sure that beneficiaries are set up. And sometimes they're standoffish. They don't, for whatever reason, because hey, there's nothing sexy about death and incapacity, so they typically don't want to talk about this stuff. They want to grow their clients' money so their business is doing better and the client's doing better. So I'm biased, right? So my opinion of what makes a great advisor is someone who is really looking at everything and not just growing their retirement. Above and beyond estate planning would be taxes. And I'm not just talking like doing someone's, tax return at the end of the year. When you have business owners and, really taking a look at that. I mean, I remember me personally, I switched CPAs and my CPA saved me an incredible amount of money in the first year because of something my prior CPA didn't catch,
Yeah.
right? So I think what makes a great advisor is someone who cares more than just about growing the investment portfolio and is really looking at everything to health, capacity, their taxes, their estate planning, and also, and I'm sure, Adam, that you have things of um, what you like and don't like about attorneys in general or estate planning attorneys. But sometimes advisors, they might think they know, an answer to an estate planning question. And what does not make a good advisor is someone who advises on estate planning when they shouldn't be. You know, as I've said before, I am not going to advise a client, "Hey, you really shouldn't buy NVIDIA." I know nothing about it, but I know enough that it sounds like a great company, but I'm not gonna go and tell your client to do it. That's your job. And so reverse that, when I hear advisors say, "Oh, you don't need a trust or you don't need that." It's like, leave that up to the attorney. But taking a comprehensive approach is what I think makes a better advisor. For me, I'm not gonna refer a client to someone who is just focusing on selling insurance products, and they don't consider everything else. So someone who looks at everything.
Maybe a spin-off question from that, but more relationship based. What would you say the best ways that financial advisors should be building relationships with people like you and maybe things they shouldn't be doing, maybe pet peeves perhaps?
I think a good way to build relationships with estate planning attorney is just open up the dialogue. So you call me, other advisors call me just with questions like, "Hey, I've got this scenario. I'm not the expert." It's not even a referral, so it's not quid pro quo. Like you're not referring someone to me. It's just that you're going to someone with knowledge to try and help your client. Because I don't know about other attorneys, but I genuinely love those calls because I got to help someone. I'm not charging for it. And even if I know that advisor, they're not, maybe their estate planning's already done. But I think that's a great way. Um, you get in what you put out. So, of course, you have to spend time, with those attorneys. I would say what doesn't work is the quid pro quo mentality. Like you said, 83%. I could tell you, I have 550 new people that I meet with a year. 550 new faces, whether they found me on Google, I write in the newspaper, my teaching from advisors, CPA, whatever. 550. Maybe 10 of those people don't have an advisor. And of those 10 people, you know, they don't have millions of dollars sitting in the bank. So it's unrealistic for an advisor to, and someone told me this once, and that, I went to a Christmas party, but timely because it's November. And he said, "I'm gonna refer you clients, but in return, you have to refer every single person to me." It's like, it doesn't make any sense.
Wow.
It's like, well, is there a minimum? Is your location of your office a factor? Does the client wanna work with a woman, or a man? Um, do you work with business owners? Like, there's so many questions, and for me, I'm gonna refer someone who I think is the best fit.
Mhm.
Uh, but even when I get those people, there's so few far in between. So that would be a bad fit, and that's how I feel about that.
No, that's fair. No, that's exactly what I was looking for because I think people need to hear that. They need to hear
Yeah,
the truth because it's not easy, right? Everybody's trying to grow their business, so you got to do it the right way. All right, so I'm going to say 60 to 90 seconds rapid fire to close out. I got 4 questions for you. Number 1, the most overlooked estate planning document. Number 1 most overlooked.
financial power of attorney.
Financial power of attorney.
Yeah,
And
and
why?
it's the most important. It's overlooked because it's often not done right. A lot of times people will do these online, and what they don't realize is there's so many things that I see every day of how banks change. The reason it's not one document fits all. Banks are changing their rules every single day. And so even my own document that I use today may not be good next year because PNC Bank or whoever, sorry PNC, changes their rules about what they accept. I just had it happen to me last week, and I've had a paragraph in something that I've used for the last 10, 15 years, and now all of a sudden they changed the rules, and so because of the changing laws and how banks are changing their rules, it's overlooked and how that needs to be updated a lot.
We've been teaching clients and for since 2007 that just because you have financial language and a general power of attorney doesn't mean the bank's going to honor it. You need a
Correct.
financial power of attorney as well.
Yep.
What's one thing you wish every financial advisor understood?
Trusts.
Trust.
Yeah, I think that the need for a trust, especially for real estate, all too often I hear, "Oh, you don't." My advisor told me I don't need a trust. I don't need a trust. I mean, I'm just baffled, and I think it's because, and I hate to say this, um, I think it's because they don't understand or they've had a bad experience of maybe with an attorney who didn't know what they were doing, or maybe the client situation wasn't right for a trust, and they had that experience or they don't understand, and then they walk away from it.
Maybe
And
try to
they don't
save the
realize
money.
this. Yep, they in the interest of time on their end, because it is work on the front end to fund a trust, but they don't realize the aftermath of what happens. Up, brother or sister that they've named is in a nursing home, goes to the nursing home. Up, the advisor's not dealing with the real estate, so they're not on that side of things where that's going through probate, and it's just a huge mess. Um, yeah, I wish they understood trusts.
Biggest mistake people make after drafting a will.
Thinking it avoids probate. I mean, I say it until I'm blue in the face. I could say it 5. I mean, like I said, I teach, right? And I'm in a retirement class, and my students are all older than I am, and they're in their 50s, 60s, 70s, and I'll say it 5 times. And then they'll ask a question, and it's like, I just told you.
Yeah. Daily ritual that keeps you sharp. Last question.
Exercise.
Exercise.
Yeah,
Anything-
I don't. It's not every day though, so I'm gonna say a weekly ritual. Um, yeah, definitely, it's so important. For me, it's 3 days a week. That's it. But I don't care if I'm on vacation, if I'm out of the country. I was in Europe last year, and we were on a whole, uh, whatever you call it. It wasn't a cruise, but a trip
Mhm.
and, a tour. And the first thing I did is I looked where the gyms were at. And it sounds stupid, but it's just, you know, that is, something that I don't deviate from, and, that keeps me sharp, I think.
I always
Yeah.
feel like it's easier to work out on vacation than it is when you're not on vacation because
Really?
yeah, for me, it's like there's nothing going on. There's nothing to do. You're just on
Mm,
vacation, right? All the
yeah.
time in the world, at least for me.
That's true, I never thought of it that way.
Yeah, I feel like whenever it's I have a harder time wanting to get one more thing done, send one more email, and maybe 2 more, maybe 3 more emails, and to
Yeah.
get me out of my routine. Whereas when I'm on vacation, it's just like I always get up earlier than my wife and a lot earlier, and it's like I'm sitting there kinda looking around going, "Okay, let's hit the gym up," and then if I feel really good. But anyway, well, Dan, this was awesome. Thank you so much again for joining me, breaking down estate planning in a way that's not only practical but incredibly useful, especially for financial advisors. For anybody, speaking of advisors, any of you who are listening, who are watching, that you want to connect with Dan or learn more about his firm or just ask questions, all of his links for contact information are in the show notes. And to everybody tuning in, there are thousands of podcasts out there. You chose to spend your time with us today. So thank you so much for listening, and we'll see you next time.
Thank you for tuning in to the Advisors Fuel podcast. For more articles, videos, and resources, or to schedule an intro call, visit adrenalineadvisor.com. This podcast is for informational purposes only and should not be relied upon as a basis for financial or legal advice. Always talk to your compliance department before implementing any of the ideas shared in this episode.